Welcome once again. Today's topic: variation or setting aside of care and contact court orders. Care and contact is a general term. The same applies, for example, guardianship rights. If a court made an order that one party should have contact on a Saturday, Sunday, Monday, or every second weekend, half school holidays, etc., can that order be changed later? Is it possible? What needs to be done? What are the requirements? What does the court look at? We'll discuss those specific issues in today's live webinar. Regarding guardianship rights as well. Can the court change the guardianship rights? For example, the court made an order stipulating that both parents should consent for the minor child to be enrolled into a school. Is it possible for later on for that order to be changed so that only one parent's consent is required for the minor child to be enrolled in a specific school? So that's a topic today. That's a discussion we'll be having. If you are watching this video live and you have any specific questions you'd like to pose, feel free to do so on the Advocate Muhammad Abdullah Facebook page. Please note, if you pose a question later on, when you're watching this video later, unfortunately, we would not be able to answer those questions because they come in from all different platforms and we do not have the time for that. But if you are watching it live, you're welcome to pose that question now, and I will keep my eye out for that specific part of my screen dealing with live comments. Let us begin. Variation or setting aside of care and contact court orders. This is the two scenarios where generally a court would make a care and contact order. The usual scenario, the most popular one, would be upon divorce, where the parties gets divorced and the court will have to make an order regarding care and contact in relation to the minor children. Usually and often the parties will enter into a consent paper, a settlement agreement, or a parenting plan. All those documents could potentially deal with the parental rights and responsibilities of the parents. For example, who has custody or primary care, where does the child predominantly reside, basically Monday till Friday, and who has contact on the weekend, and so on. That will all be outlined in the various documentation, which will ultimately be made in order of court. So that's where the divorce court comes in. Another scenario could be where the parties were not married to each other, and they're now separated, and they are having problems regarding their parental rights and responsibilities. And the parent now approaches the children's court to enforce his or her rights or to confirm it, whatever the case may be. And the court ultimately makes an order regarding the parental rights and responsibilities. Another scenario could be where the parties approach the High Court, one of the parties approaches the High Court in regard to a care and contact dispute, and the court makes an order. So those are the scenarios: divorce court, children's court, or the High Court. And the court made a final order. There is no hierarchy of the value or the authority or the power of the order. If a High Court made a court order, or the children's court made a court order, or the divorce court made a court order regarding care and contact, all those orders are court orders, and if you violate those court orders, you're committing a criminal offense. So that's the starting blocks. The court order has been granted. Our other videos, the other scenarios, dealt with the issue where there was no court order in place. However, today we are dealing with a scenario where there's a court order in place. Now, the general reason to vary or change or set aside meaning cancelling the court order, would be if there has been a change in circumstances, comparing to the circumstances when the court order was initially granted and the circumstances later on where you want to vary the court order. So for argument's sake, I'll use a silly example. When the court order was granted, both parents lived in the same home and they came to an agreement that they would have shared care, so they will continue with that. The father will most probably move out of the house, but he will see the children 50-50. Later on, many years later, the mother remarried and she does not have time for the minor children anymore because she developed herself. Maybe she has a job that demands from her the specific commitment that would be required to fulfill the job. So under those circumstances, the mother no longer can care for the minor children 50-50 half the time, and the father takes on that responsibility. So I'm trying to go towards our scenario on the screen. Under those circumstances, clearly the facts have changed, the scenario has changed, and it makes sense for the court order to change. So those are the general scenarios. The other scenario could be, for argument's sake, whereby the father has reasonable contact. He has contact every second weekend. Perfectly fine. But as things developed, as the children became older, or the child became older, they started finding it better to live with the father. Maybe because of father's academic history, he could possibly assist the children better with school, or they prefer to be with the father as opposed to the mother. And holistically speaking, the father can care for the minor children better. Things have developed, things have changed. The father may be remarried or the mother remarried. I do not know. I'm using a general scenario. But logically speaking, it will make more sense for the minor children to reside with the father. They will be better cared for by living by the father. So circumstances have changed. And under that scenario, my last scenario, it makes sense for the order to be varied, as opposed to the father seeing the minor children every second weekend, for him to be the primary caregiver, and for the mother now to see the minor children every second weekend. But there's a court order, so the court order needs to be changed. The question on the screen goes as follows. My ex-husband and I divorced in 2010. In terms of the divorce order, custody was awarded to him. I would then see the minor children every second weekend and half the school holiday. So the mother would have reasonable contact, the father will have primary care. That happened in 2010 in terms of a divorce court order. However, in 2017, the minor children lived with me due to my ex-husband having to work abroad. This continued to be the case even when he returned to South Africa before the lockdown. So he returned to South Africa maybe the end of 2019 or the start of 2020. The minor children are now 15 and 16. Is it possible to change the divorce order to afford me primary care legally? So how do I deal with such a situation? Number one, if the mother is exercising primary care despite the court order not allowing her that is good. The question is, do we need to change the court order? She's not in violation of anything. She's actually caring for the minor children more than she's supposed to care for the minor children in terms of the court order. So she's not violating any court order per se. The question is, do we need to go to court to vary this court order? Obviously, there are certain implications. There are monetary implications, firstly, in the sense of legal fees. A lawyer will be approached and he will make the necessary application to court, draft the documentation, appear in court, serve the documentation on the various parties, the office of the family advocate and on the father and so on. Whatever the case may be. So there is a bit of work involved regarding that. The question is it necessary to make the application, or can we wait it out until the minor children turns 18 years old? One child is 16 years old, who will be an adult quite soon. The question is, should we approach the court, or can we leave things the way they are? Now, that's the first question I will ask. Do you require legal assistance? And generally, the reason why a parent would require to vary a court order to allow him or her to be the prime caregiver, because the other parent might be threatening or telling the one parent, you better, dance to my fiddle. If you do not do that, I will demand, or I will take back the minor children. I will be the primary caregiver again. And he shows a court order which stipulates that he is a primary caregiver of the minor child. That could be one good reason why the mother wants to formalize this new care and contact arrangement. Other problems that could potentially arise would be guardianship issues. whereby the one parent is no longer available, is always gone, and she would like to vary the court order, now allowing a certain guardianship rights because the other party is no longer available. And because she is now the primary caregiver of the minor child, despite the court order, sorry, the de facto primary caregiver of the minor child, despite the court order not affording her that specific rights. So there are various reasons why a party would want to change the court order. And the weaker reason will obviously be just to formalize things, in case something happens in the future. There's nothing wrong with doing that, but at the same time, there is a financial consideration and time consideration at least, whereby you'll have to now approach the court and explain to the court and try to convince the court that it would be in a minor child's best interest for this arrangement, this new arrangement, to be formalized by an order of court. So, in answering the question to the specific questioner, it is possible, yes, you can change the court order to allow you to be the primary caregiver of the minor child and the other parent to have reasonable contact to the minor child, maybe every second weekend or whatever his or her work now allows it to be. We have mentioned in the scenario that this person has to now work abroad, work overseas, or work out of town, whatever the case may be. And under those circumstances, it will make sense to vary the court order so that the mother can have peace of mind and she would not have to be worried all the time. Your dad might come tomorrow and say, in terms of the court order, I have primary care, or you might take that specific order to the police station, whatever the case may be, and then she approaches a lawyer, which might be a bit challenging because there is no, wiggle room. He has a court order, the minor children will have to immediately be returned to the father and needs to urgently approach the court. But at the same time, why leave things for the last moment? It's better to approach the court bit earlier so that you have enough time. Give the father enough time to file his opposing papers if he wants to, and the court can properly deal with this matter and the court can make a proper decision regarding the facts before it. Therefore, in conclusion, it is possible to vary a court order despite it having been agreed upon some time ago between the parties, despite the parties having litigated upon it. They fought in court for a few months, for a few years. The court made an order. However, the requirement would be there should be a change, a substantial change in circumstances, something that merits a variation of the court order. And in my view, a very good reason would be that the circumstance or the status quo has now changed. Where one parent now cares for the minor child primarily, as opposed to the other parent who did not. Other good reasons would be that one parent can no longer care for the minor child. Let's say one parent became very ill, unfortunately, psychological issues, and so on. The one parent's circumstances have drastically declined. For example, does not have a proper place to live with the minor children or provide care for the minor children. For whatever the reasons, those are other reasons which you have to look at from a case-to-case basis. One person, for example, develops certain psychological disorders, schizophrenia, bipolar. They cannot be managed, and it detrimentally affects the minor children. It's very important. People will feel ill all the time. That's acceptable. There's very good medication for that. But if the scenario dictates and the professionals agree that this specific person cannot primarily care for the minor children, they're at a stage of development, they're quite young, that they require somebody who is capable of caring for them, and the caregiver in terms of the court order is no longer capable of doing so, then the court will obviously have to look at the matter and make a decision. Thank you very much for joining me on this webinar. I hope you benefited from it, and I hope to see you online soon.